the stickers you want to stick.
I thought Zion was up.
What's that?
I thought Zion was still in his exam.
No, I was up on cross already.
Well, Judge, they had an objection at the end. I don't think it was quite done. I mean, we need to figure out that report.
It's still privileged, so you guys are supposed to avoid it.
I think what he's testified to it. Is the jury going to get an admonition on this? Or?
Well, how can I admonish them on it?
Oh, excuse me, I misspoke. Is that going to be? Are they going to be advised to disregard that question and answer?
Well, we were going to talk about that before we started. We just have technical difficulties going on right now.
Understood, Judge. I'm just.
I mean, I know that.
Well, according to Paul, there's no internet hooking into it. And someone has been playing with this since I last left it, because I had to take it all back down and bring it all back up. And then somebody came in and turned it off, and they tried to bring it back up again.
That was me. I talked to that. I didn't see the
Okay.
fish guard door.
Why don't you go back there and tell them we're having Monday morning technical difficulties, and we should be with them momentarily.
They know. We have one person we're waiting on.
Probably stuck in the west side traffic.
Yeah.
Here's another reference to
Some of the searches on here.
Okay, so
Go Disney World. My Wordy is the
thank you. I have no further questions. Cross Mr. Biles.
No, I'm signing as me. These are yours?
Those are mine.
Dr. Gina Moody would be mine.
No, you signed it on my laptop.
Yeah, but I'm giving my mail. I have my mail, but the Google search engine's there.
You're signing it.
In Google, how do I sign out?
You have a Google sign that you use to
I don't know.
but
I'm not gonna mess with it now.
Yeah.
One of our jurors that hasn't made it in yet, I think they were hooked up in that West Side fiasco this morning.
This is subject to criminal production.
I wonder if you bring over the portable TV and hook that in.
Just use the closed system. Yeah.
Yeah. 11:14.
Where's Pam go?
Come in here.
Is that gonna bug you too much?
No? All right, caller, the mic's gonna work?
Yes,
Okay.
good.
Well, we can't put it too far away because he's a walker. That's probably good right there. That's the best I can do, guys. So I can get documents shown. Now, will they be on our screens too? Or just on this?
Well, I get to be on.
If we can get it in a couple minutes, sure, but if not, we'll go with what we got.
I know that's interesting. Where is this going to be hooked up to?
So the overhead.
I don't have anything voted on my laptop. I was relying on the overhead.
So you do it at the low, Brad?
That's my issue, is I don't have anything scanned. And because the first day I started to use things on my laptop, and they're like, no, not working, so I was trying
Hold on for
to...
a second. Let's see if we can get it hooked up.
We still are waiting on a juror, so I mean.
Detecting device. That's a start. No internet. We can't do it today. Did we not pay our bill to jabs or something?
I'm not in control of that.
I'm gonna. Just set up. You don't have a TV remote this year. Okay. You guys have just the overhead screen. That's it. It's on here. All right. We can't see what's going on it, so I have to adjust accordingly.
Can we move it back a little bit? So that way if I need to see it, what's on the screen, it's, yeah, what I'm pointing at, that might prove challenging.
Well, I got the jurors need to see it too.
So somewhere in the middle, I guess.
Let's see, then you got that jurors will be blocked out on the bottom.
Well, maybe we could test something and see. Test the document and see.
Mr. Thomas, can I bug you for a second to come up here and look at something?
Oh, sure.
Put it on there. Can you see that from there? Or is that put in the way?
So maybe like the lower left eighth of the screen or so is blocked,
Yeah.
or the lectern.
Why don't you move it a little forward then?
That one doesn't have a microphone. You can use it as an extra table.
That's his crutch.
You know what, right there, I think that should work fine.
Can you see there, Mr. Thomas?
Yeah.
Okay. We'll make this work. Thank you, Bob. Let me know when this is hard, my friend. Got them all? Okay, well, we're gonna put some stuff on the record. Of course.
Should I bring our client, Judge?
We need a couple of minutes here first.
Let's see how this is. We'll send it tonight.
Okay, we're on the record. We're currently waiting on one juror. Everybody's present. Just to put a couple things on, we have some technicality issues with the jazz system. For some reason, the internet's not hooking in. We brought in a portable TV. It's facing the jury currently. It's hooked into the overhead only. Paul is currently trying to get hold of the Javs folks to see what the problem is. He's already talked to the tech people over at the main computer center for the courthouse. Everything looks good there, so I don't know if it's a technical issue with them or not. I think that's got that issue pretty much. Paul's going to keep us informed as to what he finds out, so we're going to go with this. We broke up the other day, a decision was issued, and there was some collateral issues. Mr. Baez.
Yes, Judge, I understood your order after we received it. The only issues that I think weren't spelled out for us were, of course, how we are going to cure Dr. Roth's testimony where he made comments referring to documents that are privileged, thereby giving us the inability to cross-examine him on those points. And that was number one. And then the other issue, I think, on Swanner would be we would request that the questioning of Dr. Swanner be outside the presence of the jury so we can clear up that issue as to what report he was referring to and see if there's any further issues rather than, of course, having to go through this whole stop and break until we figure out where we are in terms of that, of what he was in fact relying on, if in fact he was relying on anything at all. So in light of that, I think those are the two present issues for the court to determine as to how we're going to move forward on those points.
Sam?
Thank you, Your Honor. Pursuant to your order, we ask that Dr. Roth's testimony stand as it is. This is not newly discovered. In response to the defense subpoena twice, it was told to them that this report is based on confidential material. We are providing it as a response to your subpoena, and we will waive that privilege. So this is not newly discovered as regards to Dr. Roth. They were fully aware of where he was getting that information based on privileged material. In fact, we, as attached to our motion, Judge, were emails between Ms. Grubb and Ms. Anepchi regarding this document specifically as to stipulating as to its authenticity, which was agreed upon as long as a proper foundation was laid, and Dr. Roth testified personally as to it. So we don't believe that there is any further clarification needed for Dr. Roth's testimony. Dr. Swanner's testimony, hopefully we can arrange that later this week, and we'll deal with that when we get to it. Thank you.
Judge, we would respond to Mr. Zion by saying, first of all, it's not a report. He's referring to having access to privileged documents, and this is his conclusion or things that he jotted down after going through privileged material. So absent having that privileged material, we can't cross-examine him on it. We were, of course, aware of that, as he points out, but also aware that we weren't going to have access to that privileged material. So I don't think that changes the fact that we have a confrontation clause issue. He testified about some phantom report of which, in fact, is his work, his review of certain privileged documents, and he wrote down what he chose to write down, not some kind of report spit out by a computer somewhere at Mount Carmel. So,
But didn't you solicit the information?
I haven't questioned this witness yet. You're talking about prior during pretrial motions?
Subpoenas.
Oh, excuse me. Yes, subpoena, excuse me. It's early. So, yes, we did, but this is in the fact-finding phase of the case as to whether we get some information and whether it's admissible or not are two completely different things. And in this case, it wasn't admissible because it came from privileged documents that the hospital still maintains and chooses to maintain the privilege. And the court ruled. So, This is all based on, if you look at the timeline of events, there's a court order precluding us from accessing this information. In addition to that, there's a witness testifying or writing things down for which he got from this information. Yes, it's great to have, but if we can't cross-examine him on it, this is an adverse party who is an interested party in the case, and we should be able to properly cross-examine him with the documents and with the proper materials that we would have to be able to accomplish such a thing. I would like to have what he relied on, and that's the only way I can properly cross-examine him. If you looked at these papers, I need to see them too to be able to see if you're lying or not, and I can't. So they can't have it both ways, having their cake and eat it too. And in fact, the prosecution was aware that this was based on privileged information and improperly solicited over our objections. So this is the mess they created, and not only with one witness, but with two witnesses, and we've been dancing around and tiptoeing around the tulips the whole time with these report issues. It's not something that they kind of slipped out. This is something the court has worked diligently to try and make the right calls based on the limited information that it has, and as well as all the other parties involved. So they can't claim that this is some kind of a accident or mistake. They intentionally sought out testimony from a witness where they knew we couldn't cross-examine them on it. And I'll just leave it at that before I say.
Okay, Dr. Swanner's testimony is a separate thing from Dr.
Right, we're not talking, we're talking about the current witness.
Right, Judge. I mean, it was clearly spelled out in a letter from Mr. Peterson in response to their subpoena, and then later on by Mr. Gobble from Jones Day as well, when a title was put on top of it to make clear what this data pull was. He had put that in, they had put that in the letter originally, saying this is based on privileged material to Ms. Menashe, and we're not waiving that, but here is the information you've asked for. And then when we met and asked, how do we know this is what that says, States Exhibit 27 prime, he said, well, it's in the cover letter, but I'll add it to this. And that was in November. He'll add the title to this. And he wrote another cover letter to both parties in November and said, here it is again. We've just put a title on it so it's clear what it is. And in that letter again, which is in discovery, which we've attached to our motion, it again states, this is based on confidential material, and it is, we're giving you the information, but we're not waiving privilege as to that confidential material. So, and then like I said, it wasn't like we were trying to slip anything in, Judge. We emailed them ahead of time and said, this is a very important document to us. Can we talk about its admissibility and the parameters of it? We attached that subpoena. Ms. Menashe responded. Okay, we'll work with you. So it's not like we snuck this in on anybody, Judge. And then it wasn't until it had actually been testified to that there was an objection. So this was not subject to any type of pretrial motion or a motion limited by the defense. So I would take exception to those characterizations. This was something that we had worked on, we had addressed, we had brought to their attention specifically that we were going to elicit through Dr. Roth, and it wasn't until the end of this testimony that there was an objection. So we would ask that his testimony stand at this point, Your Honor.
Had you just finished your testimony?
I had just finished it, and then there was an objection based on...
You guys, I was busy trying to get a decision out on Friday for you guys, so...
I'm sorry?
I was busy getting a decision out on Friday. I didn't get a chance to talk to my court reporter about where we left off.
I believe we left off with me having no further questions, and then they asked to approach, and that's when all of this came to light.
Okay.
You ready?
Judge, may I respond to this last information given to the court? I realize they take exception with my prior comments, and I'm certainly going to take exception with these. But now, this is just straight up trying to mislead you. All of the emails that were sent from Ms. Grubb to Ms. Menashe were about this document. Had nothing to do with this document. In fact, we all had a sidebar with the court, and the court
waving
looked at this document.
documents around the court report.
Sure. I'm sorry. States Exhibit 27. is what was the subject of the sidebar. It's what the prosecutors showed the court. We had Ms. Menashe come up, and she confirmed the conversation. We had this whole conversation at sidebar over State's Exhibit 27. Now he's trying to pass off that this whole conversation revolved around State's Exhibit this other State's Exhibit 27, which is a completely different document. I don't know why he's labeling it the same.
27 prime is what it is.
I'm sorry?
27 prime. Little accent over it?
Yes. Okay.
That just shows us it's the same exhibit, just different format.
It is not the same. Well, it is not what was sent around, and it is not, and it did not have this title up top. So we're talking about two completely different things that would have placed us on this. To me, I read this and I say, okay, well, it's a summary document, and that's what it was passed off as. This then gives more information where they say, where it's titled, and I'm referring to 27 prime, where it states, all instances in which patients within Mount Carmel Health System Hospital received a dose of fentanyl at or above 500 micrograms while not in an operating room setting or on a ventilator, September 2013 to September 2020. And it says all instances. I don't have anything to be able to cross-examine him on this. And I don't have any of the documents to be able to say, to be able to ask him, to be able to inquire as to whether this is all of the specific instances. This is one man's testimony based on one man's research, and he took it from privileged documents that we don't have access to. So for him to get up there and be able to testify to something that is a fact, we should be able to confront him on it. And then to try and pass these two documents off as if they're the same thing is simply just not appropriate.
Why wasn't this raised in your pleadings Friday?
I had no idea that they were going to try and pull something like this.
He went we labeled it on the record.
I saw him label it on the record, but I didn't have any idea what he was doing in terms of that. Well, all I knew is I was objecting to all this privilege stuff coming in, regardless of what he decided to label it as. But now, somehow, they're passing off an Excel spreadsheet to try and make it look like it's a computer printout, number one, and then adding some type of sentence or two which bases an actual conclusion of fact. And one, nothing could be further from the truth on that, in terms of that it is an actual computer printout, and two, there's no way to cross-examine him on this. That's it.
Okay. Well, I don't see a value in giving them some type of limiting instruction. It's privileged material. It should have never been solicited. It's out there, I realize, but am I going to bring accent to it by saying something to them?
I think we're going to assume that this jury, we all went into this case assuming that this jury was going to follow your instructions. And if you instruct them that they are to disregard that question and that answer and not consider it, I think in terms of the record, for appellate purposes, and for the final determination of this case, they have to be able to follow your instructions. And look, I don't like the fact that you have to point it out and bring it up to them at all, because it never should have been solicited in the first place. But we're in this position, so something has to be done about it.
Okay. You want to bring them?
Sure.
Anything else to the record before we bring them in?
Just so we're clear, Judge, are you going to give a limiting instruction or not?
I'm thinking.
All right, well, if you decide to, we have additional things we would ask then after that.
What are you going to want in addition if let's say I do say you disregard the last answer and question. What else are you going to need?
We've asked to recall this witness. We will subpoena him and ask him to recreate that document, not using privileged information, see if it's possible.
But you can do that on redirect.
Not if you say we can't ask it. And not if you're limiting that question as being disregarded and stuff. So
So do you want it on a sidebar? Or do you want to proffer it? Or what do you want to do? I'm still debating on whether I should give it or not, because I don't think it's a particularly great idea right now.
Judge,
But that's my gut.
my understanding of this situation is they asked for this information, and they were provided this information with the understanding that we use these confidential Greeley reports as a way, because the information had already been gathered. So we looked into those reports that the court had deemed confidential and produced this for you and told them that. And then when I was like, what does this document say? And that was, as I said on the record, I wasn't trying to sneak anything in. 27, I believe, is what was shown to Mr. O'Brien. I just had it mislabeled. And 27 prime is the report that clearly says Husel's the only one doing this in the whole system. So, and that was just a mislabeling. We had 300,000 documents, and I said that clearly. So Dr. Roth used the confidential material to respond to their subpoena, told him he was doing that, and here it is. Only Dr. Husel's using that. They were trying to find every other doctor in the system that does what Dr. Husel does. Well, guess what? No other doctor in the system does it. Here's your report. So, and then Mr. Gobble in November said, I'll put this clearly on the top of it. That's what 27 prime is. Then we said, hey guys, we want to introduce this, and you saw those emails relating to 27 prime. So we believe, we don't know because of your admonition, can't talk to Roth during the weekend. We believe that because his report is just based on medical records of patients at Mount Carmel in the system that they can go through it long form without using the work already done by Greeley, we think anyways, and reproduce that report, assuming they come to the same conclusions, assuming that Greeley was correct, and then present all of that. So
One
that's
second, Dave.
So if the court says you can't use this information, you have to disregard it, I think the only way we can, get that in front of a jury, which I believe is relevant, is to ask Dr. Roth, we'll subpoena them, and, we've got another 8 weeks here together, so see if you can do it within 8 weeks and ask to recall them, would be our option B on this.
Okay.
Thank you.
Of course, we would object to that. We weren't given proper notice of that. This is now, this is basically an expert report now, because here's the thing.
Okay, it's an issue of fact, though. It's not an opinion.
No, it is an opinion, because he's reviewing
how so?
records.
If they go through the records and they produce a A to B, that's a fact. It's not A, I believe B.
What it is him going through records and making determinations that constitute these facts. So that's the issue here. And we keep calling it a report. There is no report that could be ran to see if this was in fact only Dr. Husel. This was something they had to do by hand. So therefore, and by reviewing records, so therefore he had to come to conclusions and opinions.
Okay, you made your record.
I have.
Okay, let's bring the jury.
So, do we know what the court's going to do? Or?
I know what the court's going to do.
We would like to know.
Well, you'll find out, won't you? I am not going to give a curative instruction at this point in time. I want to see where it develops.
So how do I address this in cross-examination? That's where I'm...
Carefully.
Judge, I need a little more guidance and carefully.
Well, I'm still trying to figure out how all this post stuff's relevant anyway. Okay? But that's aside. I would just leave it alone for now, get going for a while, and then we can see where it goes, and then I can, if I change my mind, I'll let you know. Or you can try to tackle it, but you got to do it carefully. You can be seated. Ladies and gentlemen, Jerry, I hope you had a great weekend. We're going to continue with the testimony. Mr. Baez, you're across.
Yes, sir.
We need the doctor in here. Doctor, remember you're still under oath. Go ahead and get yourself situated. We're going to speak up. And ladies and gentlemen, the jury, the vote on Friday was we're going to be taking this stuff down, but we can't officially do it until the city does their thing. So you may be pleasantly surprised this weekend on what might happen. Of course, I'll probably be in line, but that's beside the point. Okay? Mr. Baez.
Please support. Mrs. Ayala. Good morning, ladies and gentlemen. Good morning.
And before you get started, I should explain that device there right beside you.
Yes, sir.
We're having technical difficulties on the big screen. So we went with Plan B, okay? It's to aid and assist you. It's not as nice as the big screen, but we're doing our best until we can figure out why our provider doesn't have us connected up so we can do our thing. So, with that.
Good morning, Dr. Ross.
Good morning.
Sir, this is the first time we've met, correct?
Correct.
And we've never spoken prior to today.
That's correct.
And yet you have had numerous conversations with the prosecution on this case.
I've had two, yeah.
2. Okay.
Can you guys hear him okay? You want some volume? Give us some volume there.
Yes, Judge.
Sir, how many times prior to this case had you been to Mount Carmel West?
Prior to this case?
Yes.
Probably 2 or 3 over the years.
Okay. And you testified yesterday. I'm going to slip up and say yesterday. You testified during direct examination that you are the chief clinical officer, correct?
That's correct.
It is a fact, sir, that your title is you are the executive vice president at Trinity and chief clinical officer. Isn't that a fact?
That is correct.
Okay, so the chief clinical officer is actually your second title. Is that fair to say?
I suppose there are a number of executive vice presidents.
Okay, but you're basically, as it relates to this case, the guy from corporate. Fair description?
That's one way of phrasing it, certainly.
Okay. Now, in light of that, Trinity has 88 different hospitals,
Thereabouts, yeah, that's right.
and it is a $20 billion corporation,
Thereabouts, that's correct.
and you were sent down to lead, I guess, to be the point of contact on behalf of Trinity.
That's correct.
All right. Now, you testified that, remember, let's talk about Project Lighthouse for a minute. You testified during direct examination that Project Lighthouse has tens of thousands of documents in it, correct?
That's correct.
It surprised you to know it was 273,000 documents?
It wouldn't shock me, no.
I drew the short straw, so I had to read that. Now, in light of that, sir, you guys went over everything. You guys had a plan for social media, correct?
Correct.
You even developed questions that were being asked and how to answer them, correct?
Yes.
All the way down to a Facebook post, right?
I'm not directly familiar with a Facebook post, but
Okay. If someone commented negatively on Facebook about Mount Carmel, there was a protocol on how to answer and when to answer, right?
not to my specific knowledge, no, but
You can read that, those documents,
not that I recall today.
okay? Then, in fact, you had the media broken down by individual TV channels as well as print media, correct?
Not that I directly recall, but probably.
Do you recall reading or into a lot of these documents today, sir. You came prepared to answer them though, right?
Yeah, to the best of my ability.
So every single channel was broken down as well as their questions, correct?
Not that I directly recall, no. Not to that degree of specificity.
Do you recall that there were even statements of off-the-record conversations with the media?
Not that I recall.
You do know what an off-the-record conversation with the media means, though, don't you?
I do.
Okay. And so the ladies and gentlemen of the jury know this. This is when someone wants to tell the media something, but they don't want the media to tell the public who in fact gave them that information, right?
I'm not an expert on what the definition of off the record is, but it sounds generally true.
But you would agree with that statement generally, right?
Generally speaking.
Okay. And that's not exactly the picture of transparency that you testified to under direct examination, is it?
Well, speaking generally, doing other things, sometimes that's not about being not transparent. It's about providing information on a topic.
Right, but if you don't want the public to know where it came from, that's not being transparent with the public, is it, sir?
It depends on the nature of the conversation.
So, in your definition of transparency, it's okay to give information so long as people don't know where it came from.
No, I would not agree with that.
Okay. But you would agree that there were numerous off-the-record conversations with the media on behalf of Mount Carmel and Trinity that did occur in Project Lighthouse.
And that, as I said, not that I directly recall. And again, oftentimes they are about, details about how things function, not about things that are contrary to what's being said.
I find that answer interesting, sir, when you, in fact, were the point person for Trinity on all things press-related, were you not?
I was one of them.
Okay. So, and you do your job thoroughly, right?
To the best of my ability.
Okay. So, you didn't testify about anything having to do with the press on direct examination, did you?
I only asked the questions that were given.
The prosecutor went from the first call you got on this case to the last thing you did. Remember all those what happened next and what happened next and what you do next questions?
Generally speaking, yes.
And not once did you tell the jury that you were the point person on behalf of Trinity for all things discussed in the media.
Objection, Your Honor.
Sustained.
Not once did you testify about the media under direct examination, correct?
Objection, Your Honor.
Sustained.
Let me ask you this. You talked about this villain document. Do you remember that?
Yes.
And do you remember, sir, being shown State's Exhibit 27A? Do you see that there? I can't.
Yeah, it's up there.
Okay.
I know it's not what it used to be.
Witness maybe not see it.
Okay. Can you see that, sir?
I cannot see that.
Okay. I'm going to twist this a little bit your way. Oh, no. Can you see it? You might need to leave.
Yeah, I was going to say, if it's okay with... I'm
Why
going to...
don't you do this? Why don't you leave it where it was and you hand them the actual document where you need a copy for your screen, don't you?
You know what, Judge? I can run back and forth. I got decent legs. Remember that document, sir?
I do.
And you remember being asked by the prosecutor about the fact that that document didn't have a logo on it and stuff like that? You remember those questions?
I do.
And in fact, if I can find the document, give me just a second. Thought I had it. Can you bring that up for me, Allison?
Can't bring it up.
I think I might have found it. I need to put a sticker on it. Now, the way things work during Project Lighthouse is someone would submit a document or some questions or some statements, and then it would kind of get passed around and people would make comments, right?
Generally speaking, yes.
Okay. And then after that, decisions would be made, correct?
Generally speaking, yes.
Okay. I'm going to show you now what's Defendant's Exhibit MCD6. Okay, first I'll bring it up so that the jury can see it, and then I'll kind of figure this out. Can you see that, sir?
Not exactly, no.
Okay. May I approach, Judge?
You may.
Can I do it constantly without?
Yeah. We're going to adapt to fit the screen.
I'm taking back from you 20 seconds.
A little bit magnified.
You can do that on this.
Yeah.
Wind shut.
Okay.
You see that?
Yes, sir.
All right, let me get it so I can show it to the jury.
Yeah.
It used to be that we would just like either wave it by you or, so technology's created this monster, so to speak. Well, when it didn't work this morning, it did not make my morning at all. So let's see if we can do it there.
I'm going to zoom in first, and then I'll bring it to...
You can't see how far you zoomed in.
I can see it through the reflection on the plexiglass, so that plexiglass is serving some purpose.
A little smaller.
All right, let me... actually, I need to make it smaller now.
A little smaller.
Say, right there? Okay, good. Okay. Do you see that?
Yes, sir.
Okay. Now, you recall when you read this, it talks about, after seeing version 1, emails between Mark, Brett, and Melissa about gaining alignment on big themes. Do you recall that?
Yes.
Okay. So this is, in fact, a Mount Carmel document, right?
Yes.
And in fact, it's internal, right?
Yes.
And it is labeled confidential. Do you see that at the bottom? Can the jury see that? Where I'm putting it? Okay. Do you see that? Confidential?
I see the word.
Okay. All of these documents from Project Lighthouse were in fact confidential documents, were they not?
I don't know that all of them were, but many of them were.
Well, that's why you called it Project Lighthouse, so it could be protected under the attorney-client privilege, right?
Objection, Your Honor.
He's not qualified to answer that.
Okay. Sir, these documents were ultimately disclosed because of the lawsuit with the nurses against the hospital, correct?
Objection, Your Honor.
If you don't.
Okay, I'll let him answer. Do you know?
I believe that's correct.
Okay, so they were never supposed to see the light of day. Isn't that a fact, sir?
Objection, Your Honor.
Okay, you're asking him to speculate. Sustained.
I'll withdraw the question, Judge. Now, the statements that you told the jury under direct examination about who is to be made the villain, who is to be the victim, and who is to be the vindicator. The vindicator was the hospital, right?
I don't recall what the, again, I was not directly involved in that work at that time.
Okay, but who's supposed to be the vindicator? You have no idea? One Superman, right?
Correct.
Okay, so it has to be one of the parties, right? The patient,
Your Honor.
victim?
He's answering, he was not involved in this document.
Okay, it's a compound question right now.
Sure. Okay.
Rephrase.
I'll rephrase. Under this scenario, sir, you know that the victims were supposed to be the patients, right?
I believe that's correct.
Okay. The villain was supposed to be Dr. Husel, the nurses, and the pharmacists, right?
Specific to the document that you're holding?
Yes.
I believe that's correct.
Okay. And the vindicator would be Mount Carmel, right?
I believe that's correct, specific to the document that you're holding.
Okay, now you testified under direct examination, sir, that you had an outside consultant and that he's the one that came up with these ideas, right?
There were a number, but he was one of them, the first one.
Okay, and so we're clear, the person we're talking about under this document
Okay, you remember, you gotta say what the document is.
Yes,
before you
yes,
put it
I'm
on.
still on MCD 6.
Okay.
Now, you see, sir, Mark's comments, right?
Correct.
Can everyone see that? Okay. And then right below that, all of the choices and the discussion topics. Do you see that?
I do.
Okay. Now, on the document that you were shown under direct, well, let me strike that. Let me ask you about this. Mark is a gentleman by the name of Mark Weaver, right?
That's correct.
Okay. Weaver.
Weaver.
Yes. And Mark Weaver is in fact considered the communications counsel. Is that correct?
To my knowledge, he was not functioning as counsel, he was functioning as a consultant.
Right. But you know that he is, well, you know that he is a former prosecutor of 20 years, worked for the Department of Justice.
Okay, there's an objection.
Relevancy as to Mark Weaver's qualifications and background.
We're discussing, this has been brought up.
No, he's also objecting you're testifying. You didn't ask him what his credentials were, did you?
I'm asking him now if
No,
he's
you're
aware.
testifying now.
Okay, I'll
Ask him the question.
I'll ask it a different way. Since the prosecutor brought up what you consider his document under direct examination, I want to ask you, are you aware, sir, that Mr. Weaver was a prosecutor for 20 years, worked for the Department of Justice?
Staying.
Sir, you said he was not acting as counsel, but he in fact was someone brought in because of his unique talents and skill, correct?
I wasn't involved in his selection. His selection was prior to my involvement, so I can't speak to why he was brought in.
Okay, but at some point you became familiar with him and his work, did you not?
Indirectly, yes, and I met with him, I believe, once.
Okay, and you were aware that he was the former Assistant Attorney General of the state of Ohio?
Objection, Your Honor.
I'll permit it.
You are?
I was not aware.
And were you not aware he worked for the Department of Justice?
No, I don't think I was aware of that.
Okay. So you have people making important decisions where you're the actual point person and you have no idea what their background is? Is that what your testimony is?
Okay, he said that he wasn't doing it during that time. Are you asking about his total career? Because that's really not relevant.
I think he did say, well, let me ask you about this. He was never actually terminated, was he, sir?
I don't know the answer to that question.
Okay. Well, you testified about him, you guys moving away from him. There's no document in those 270+ thousand documents that say that he is terminated, we don't want your advice anymore, or we're not going to follow your advice. Isn't that a fact, sir?
What happened was we brought in a different communications consultant and followed and worked with them to garner their advice.
In fact, sir, you're referring to Gerard?
I am.
Okay. Gerard actually has been working for Trinity prior to this case, was it not?
actually don't know the answer to that question. If it's possible they were engaged somewhere else within the system.
Sir, you're again the point person for all of this going on. Did you not know that Gerard had a 3-year contract with Trinity?
Not that I recall today.
Okay. And they weren't exactly brought on. They were involved as early as December 5th, Gerard was, correct?
I believe that's correct, but I don't remember the specific date.
So all of this is going on simultaneously, though, right? I mean, when I say all of this, I'm referring to Mr. Weaver being involved and Gerard being involved, right?
There was overlap.
So what I want to get back to is the document that you were shown under direct examination, States Exhibit 27A, which was really Defense Exhibit MCD 6. Do you see that, sir?
I do.
And you testified a few moments ago that the questions would be brought up, kicked around, comments made, and then decisions were made. Do you remember that?
Generally speaking, yes, that's what I said.
Okay. So on the bottom of that document, it states Ed's decision, right?
That's what it says.
And who is Ed?
Ed is Ed Lamb, who at the time was the chief executive officer for Mount Carmel.
He's the top guy at Mount Carmel, right?
Correct.
Okay. And this was more than just, this document's more than just something that was brought up by Mark Weaver that you didn't actually agree with. I know that's what you testified on direct. This, in fact, is what decision was made by Ed, right?
Well, I believe what I said at direct was that it was a decision in time, but not the final decision.
Now, Ed's not dead, right? Ed's the president of Mount Carmel. He's no longer with Mount Carmel, right?
Correct.
He was let go as well.
He's no longer with Mount Carmel, that's correct.
Okay. Now, the president of Mount Carmel decided that Husel would be the primary villain. The involved pharmacists would also be villains, as well as the nurses, not the two that had preceptors, right?
I don't know the date on this particular document, but at that point in time, that was the direction, was not the final direction.
Okay. And you testified you kind of changed direction at some point, right?
Correct.
Okay. And we've gone over some of those changes of directions, but there's no disputing that the president of Mount Carmel made the decision to make William Husel the primary villain, as well as the nurses and pharmacists, all of these healthcare providers, these people who worked for you. It was made, the decision was made to make them a villain by the president of Mount Carmel, correct?
Again, that was, at that point in time, that's what the document says, that's what it says, the document says was his decision at that point in time.
Now, sir, you testified that you met, under direct examination, you talked about, and in fact, when I asked you earlier, you said you met with the prosecutor 2 times, right?
I met with Mr. Zion 2 times.
Well, when I say prosecutor, I'm referring to every prosecutor that's ever touched this file.
Oh, apologies, then I met with Mr. Zion 2 times.
Okay, well, that may have been my question, but as far as your direct examination, over the last couple of days, you only discussed 2 meetings, correct?
I believe that's, I don't remember exactly, but I believe I discussed 2 specific meetings. I did not say I only met with them 2 times under direct.
So we're clear, you talked about the first meeting you did not go to. That was done with Mr. Greg Peterson, the criminal defense lawyer. And you also talked about the first time you actually met with them, which which would have been December 17th. Isn't that a fact?
Sounds right, yes.
Okay. So then, subsequent to that, you met with them, and this one you did testify to on January 10th, did you not?
Yes.
And you stated that the reason for your meeting with them was to go over what would be told to the families, to kind of get a little, I guess, collaboration with them on that?
I believe what I said, and that was the purpose of the December meeting,
Okay.
was to discuss the timing with which we would speak to the families, because we wanted to speak to the families, but did not want to do so in a way that would be disruptive to their investigation.
Okay. And then you met again on January 24th with them. Oh, no, excuse me, that was not that. Excuse me, on February 5th, you met with them, with the prosecutors, correct?
I believe that's correct,
Okay.
thereabout.
You didn't tell either the prosecutor or the jury in the last under direct examination what that meeting was about, did you, sir?
To the best of my recollection, that was a meeting where they had asked me to prepare a document that would speak to the facts, the clinical details on those cases.
And then, sir, you met again with them 2 days later on February 7th, did you not?
No, I don't remember meeting with them twice, 2 days apart.
Okay. I'm going to show you, let me get the actual. If I could have the court's indulgence, Judge, I'm sorry. I'm going to make sure I get the document that's here. Just want to show this date. Judge, may I approach the witness? Sir, I'd like to direct you, I'm going to show you the timeline from Project Lighthouse. If I could direct your attention to the bottom of the page.
Okay?
February 5th and February 7th. Do you see that?
I do.
Does that refresh your recollection as to whether you met with prosecutors on those days?
It says I did.
Okay. So
that's no, it doesn't refresh your memory?
It does not refresh my memory. I do not remember meeting with them twice, 2 days apart. I remember meeting with them in early February.
okay. So you don't remember that. Now, let me ask you this. What about February 22nd? Oh, I'm sorry. March 11th, 2019. Do you recall meeting with them on that date?
I remember meeting with them in early March. I'll assume that, I don't remember specific to March 11th, but I remember meeting with them in early March.
Okay. And then, do you remember a meeting on March 14th with the detectives?
Yes, I do remember that.
Okay. So, fair to say, you met with them a lot more than twice, right?
Again, I believe your question earlier this morning was meeting with Mr. Zion, but I met with them prior to the entire prosecution team more than twice, yes.
Now, sir, you also, remember when we were talking a moment ago about meeting with, or I'm sorry, having off-the-record conversations with the media. You said that occurred, but you weren't necessarily aware of it.
I don't recall being aware of it. That's correct.
Okay. Now, you in fact, sir, met with the Columbus Dispatch, did you not?
We did.
Okay. And you had an off-the-record conversation with them, did you not?
I believe those conversations were on the record, but
Okay. It's funny, I Googled and I looked and did research on, and I didn't see a single quote.
Objection, Your Honor.
Okay, you sustain. You can ask questions.
Are you aware of any stories coming out from the Columbus Dispatch that has your name on it, or your quotes.
I believe so, yes, sir.
So there's actual quotes of your testimony, of your statements with them?
With the Columbus Dispatch?
Yeah.
I believe so, yes, sir.
And you met with them not only once, but twice, did you not?
I believe that's correct.
So you had a little more involvement when it came to the press on this issue than you have testified to under direct examination, right?
Okay, sustained.
You were quite involved with the press on this case, were you not, sir?
Yeah, I believe what you're referencing is, when I was referencing is the early part of the process. I was involved in it later in the process. That's correct.
So your testimony is that it was something you did later on.
That I was not involved early in the process. I was involved toward the end of December and thereafter.
Now, out of the other 88 hospitals that Trinity has, how many of these hospitals had max dose policies with palliative withdrawals?
To the best of my knowledge, none did.
Okay. And so Mount Carmel was not an outlier in that area?
That's correct.
Okay. Now, you testified that the reports that were done by, I keep messing up her name. Leslie Volman, the Project Lighthouse reports. You testified under direct that there were 5 reports, right?
Correct.
And you also told the jury that that the report parameters kept being expanded so that you would make sure you had all the patients that might have been affected. You recall that testimony?
I do.
Okay. Now, I want to go over the parameters of the search,
Okay.
and I'm showing you Defendant's Exhibit MCD 14.
Can you see it? Since he didn't show it to you ahead of time.
I can see it, Your Honor.
Okay.
Okay. Now,
Somebody can.
so the first search that was expired patients, that means patients that have passed away, correct?
Correct.
Within 400 minutes from Dr. Husel, correct?
Correct.
To the patient's discharge date and time for fentanyl of 800 micrograms or greater. Do you see that?
I do.
Now, the second report was run the same thing, but the change was made from 800 micrograms to 500. Is that correct?
Correct.
That's consistent with your testimony that you expanded the parameters of that search, right?
That the team did, yes, that's correct.
Okay. And then we have report number 3, which was run on December 5th. And the change here is that you got rid of the 400-minute time. Do you see that?
Correct.
So that would have expanded the search, right?
That's correct.
And December 5th is the date that you notified the prosecutors on this case that there was a potential criminal matter, right?
That Mount Carmel did, that's correct.
Yes, Mount Carmel did.
Yes, sir.
Now, this is the report where Tracy Young's name comes up, correct?
That's correct.
And that's because after receiving 2,500 micrograms of fentanyl, she went on to...
Sustained.
Well, okay. And that report indicated that she had received 25...
Objection, Your Honor.
Let's go sidebar. You guys haven't talked to each other at all today, I know that, so get busy. Ms. Schaefer? Relax, doctor, we'll be right with you. got quite the obstacle course there for you, don't we, Ms. Schaefer? Are you ready there, Sam, Madam Court Reporter? Okay.
Yeah, I think, yeah. that's-
Ladies and gentlemen, we're going to get started back. Mr. Baez.
Judge, I was advised that it might be easier for the jurors to see, actually, I don't know.
Well, we had a problem.
All right.
We did a test run before you guys came in, and they couldn't see it back that far. But if you can see it, both of you two at the end, can you see it up there in the top?
If it could be darkened a little bit, can it be?
I can't necessarily fix that.
The answer is no.
You can't see it because of the darkness on it?
I can't, the print is really.
Plus that, I can't see what it is at all. Relax.
Glare. Can you turn the lights down a little bit?
Oh, okay.
Well, that goes into this whole panel up here that's currently spinning. It's been spinning since I got in here around 8:25 or so. Okay, let's make the best with it. Go ahead.
Doctor, I'll try my best not to use this as much as I can, okay?
Yeah.
So let's try that together if we can. You're aware that T.Y. and Tracy Young are one and the same when we refer to them, to that person, correct?
Correct.
Okay. And you're aware that report number 3 on that was ran on December 5th, 2018, is the one that Tracy Young's name came up on, correct?
I became aware of that after the fact, but yes, her name is on that report.
Okay. Now, the question, I guess the exercise that we were going through was that your testimony under direct was that the search just kept expanding to be able to get more patients. You recall that? That's where we're at in the line of questioning?
Yes, I recall that.
Okay. And reports 1 and 2 did just that. We covered that, right? Mm-hmm. Now we have Tracy Young, right? And report number 4, which was run on the 19th, and report number 5. Let's go over report number 4 first. Report number 4 now basically goes, the only difference here now is it talks about using new medication data reporting parameters ordered at any dose, but it now limits it down to 120 minutes of the discharge date and time, which basically means that the person passed away within 120 minutes of getting the medication, correct?
Correct.
Okay. That, in fact, eliminated Tracy Young from that report, did it not?
I don't recall the specifics of that report, but it would have.
It would have, because you know Tracy Young lived for 9 days after receiving this dose of
Okay.
fentanyl, correct?
Do you know whether that, do you have actual knowledge that she lived that time?
I do have actual knowledge.
Okay, you can answer.
Correct?
Correct.
Okay. So, report number 5 also limits it to 120 minutes, correct?
That's correct.
Thereby, again, eliminating Tracy Young from these reports, correct?
That's correct.
Now, in the several meetings you had with the prosecutors, you never brought to their attention the name Tracy Young, did you, sir?
That's not correct.
Okay. And
Well, I did bring.
Hold on, stop.
I did bring Tracy
Okay.
Young to the attention of the prosecutor.
And when exactly did you disclose Tracy Young to the prosecutors?
So I personally discovered Tracy Young, not through that report, but through a different communication around March of 2019. And then I brought it to the prosecution, I believe it was in the middle of April of 2019.
And that's because Dr. Husel had brought it up to his civil attorney's attention, correct?
That's correct.
And it was the civil attorney who asked Mount Carmel for the records of Tracy Young, correct?
That's correct.
Were you involved in the decision to tell Dr. Husel's civil lawyer that you had no record of Tracy Young ever dying in Mount Carmel?
To my knowledge, that's not what was said, but I wasn't directly involved.
My question to you, sir, would be, were you involved in that decision to tell them?
Objection, Your Honor. He's answered this question. He is not aware of this.
Okay, stop, finish your question.
Were you involved in the decision to advise the lawyer that you had no record of Tracy Young ever passing away at Mount Carmel?
Your question makes an assumption that I'm not aware of.
Okay, so you can't answer, well, hold on. You can't answer the question the way it was phrased.
That's correct.
Okay, new question then.
So fair to say you were not involved in that decision if that decision was made?
If for that reason,
Yeah, I'm trying to ask it in a way that you can answer. So my question to you, sir, is your testimony that you were not involved in that decision if that decision was made?
or that the decision was made for a different reason.
Or if it was made for a different reason?
That's
your
correct.
testimony?
Yes.
So, had Dr. Husel never brought this to everyone's attention based on his experience, you would never have brought it to the prosecutor's attention.
It's been asked and answered.
I'll withdraw the question. Now, sir, you testified under direct examination that you believe that the nurses and pharmacists who were at bedside and critical witnesses in this case were spoken to by human resources after the detectives, right?
I believe some were before and some were after.
But that wasn't your testimony, was it, sir? Under direct examination, you testified specifically that the detectives spoke to, let me finish your question, that the detectives spoke to the nurses and pharmacists before human resources spoke to them, correct?
I believe what I said, but I don't directly recall, is that after they requested that, we stopped. And most of them were after.
So you're not aware that that in fact did not occur? That all nurses and pharmacists involved in these 14 patients were spoken to before, not only by human resources, but also by risk management? Are you
Objection,
aware of
Your
that,
Honor.
sir?
Assumes facts not in evidence.
Okay,
It is
sustain,
evidence. Detective Gillette.
sustain, rephrase.
Sir, are you aware that the 14 patients involved in this case were spoken to two different individuals at different times before detectives ever spoke?
Objection.
Okay, sustain. Let's go sidebar here. Ladies and gentlemen, entertain yourselves. Come on, let's hear some noise. You want me to throw you in back and make you come back? Okay.
And I have here 8 It's got peanut all over them on our soccer field. Reevaluating what's
Okay. Do we know when?
Maybe the last 30 minutes.
Okay.
May I proceed?
You may.
Dr. Roth, if I'm looking a little red, I apologize. I made a major mistake in my question. Are you aware that the nurses and pharmacists involved in the care of these 14 patients, I had said patients earlier, but I'm referring to the nurses and the pharmacists, that they were spoken to third by the detectives in this case?
Once again, objection, Your Honor. Assuming facts not in evidence.
I'll permit it. Do you know?
I do not know.
So when you testified under direct, it was your impression that the nurses and pharmacists had been spoken first by to the police and second by human resources?
That was my belief and understanding, yes.
Okay. Now, the pharmacists, I'm sorry, the patients in this case, you testified under direct examination that you met with Ron O'Brien and also the Vice President of Planning and Strategy to discuss who would speak to the patients' families first. Do you recall that?
As I said a few minutes ago, what we said was that we wanted to speak to the families and let them know, but wanted to do so in a way that would respect their process.
And you also stated that you wanted to be transparent to the families, right?
Correct.
Okay. So, sir, I want to ask you about your transparency with the family as it related to the conversations with these 13, I'm sorry, with these 14 patients. Were you being transparent with the family of Jeremiah Hodge when, and told them that 23 minutes before the palliative extubation, that Dr. Husel had performed CPR on her
Objection.
and brought her back, brought her heart back? Did you tell them that?
Objection.
I sustained it.
Did you give them that?
Okay.
Judge, I think we're going to get to a sidewalk.
Yeah, well, we can do a quick one over here. That's no problem. These guys, why don't we send them on their break just a few minutes early? And let's take 15 and then we'll deal with it. So, ladies and gentlemen, see you in 15 minutes. Have a wonderful break.
All right.
And I know I shorted you on testimony today in the first session. That was technical difficulty. Sorry. Okay, y'all can be seated. Hold on, you can speak for a second. Doctor, did you do any of the interviews with the families?
I did not.
Okay.
I think he testified he gave direction, and he was a part of this process as to what would be told to the family.
Yeah, but he wasn't there to tell the families anything.
Okay, so I can ask him a different way. I'd rather the witness be excused for this judge.
Okay. You may step out. Go with Mr. Thomas. Remember my instructions. Okay, he's out.
I believe this witness testified that he was involved in the decision-making process to be transparent with these families. I think it is it's clear and proper cross-examination material to explore just how transparent he was with these families.
Okay, but he wasn't the one who gave the discussions directly with the families. How can he testify?
Well,
Is there any memorandum of what he
Well, I
testified
can
to?
ask him if he directed anyone to make these statements.
But then you went into your factual basis there about saving lives.
Well, my factual basis, I have a good faith basis to ask him these questions because they are what's in the records. I'm not making this stuff up.
Okay, then use the records, okay? You're asking him for what happened at the interviews with the families, and you're trying to back in other stuff. So if it's on these reports, then use them with the person on the reports.
Judge, I think under cross-examination, I can, if I have a good faith basis for the question, I can ask leading questions that ask the specific witness whether or not he disclosed certain information to these patients when claiming that he was transparent. I don't think, I would agree if I lined up, if I wanted to slow it down at a snail's pace, that I could retrieve all of the records and then do one record at a time as a basis for it. But I think I can represent to this court, and if I'm incorrect, certainly the prosecutor has the ability to point out my false statements during redirect and at any point in their case in chief. But I know I have a good faith basis to ask these questions. I've pulled these from the records, and I want to ask him in a leading way whether or not he directed and challenged his lack of transparency to the families in this case.
Mr. Zion?
This isn't the appropriate witness to be asking specifics about what was or was not done in what's contained in these medical records. What this witness has testified to, it was the dosing habits at the time of palliative extubation, which was their concern. That's what the reports they ran are. That's what he is aware of. If they want to bring in an expert witness to talk about the care Dr. Husel gave them, they can. If they want to talk to the doctors that were there or the nurses that were there, they can. This is an administrator who came in after the fact, and he is not the appropriate witness to be asking these questions of. He did not participate in these phone calls, as the court stated. So this is an inappropriate line of questioning, Your Honor.
He's exactly the right witness to ask about this because he's the one coordinating with the prosecutors when and what is going to be told to these families. And he also testified that the reason he did it was to be transparent. And really, that's a bunch of baloney. And the fact that I can't challenge him on it because the prosecutor wouldn't do it that way is irrelevant. I think
He was the one who did the interaction with them, okay? You don't know what was said? Were the calls recorded?
I don't believe they were, sir.
Okay, so he did not make the phone calls. How can he testify as to what was said on the phone calls?
because he was a key decision maker as to what would be spoken about in these phone calls. And I can ask him a way, I will ask him in a way that incorporates that fact, that he didn't actually make the calls, but he directed and was a decision maker as to what would be disclosed. And then he goes and characterizes these phone calls as being transparent when in fact they were not.
Okay, but see, you want your cake and eat it too. You used your words this morning, okay? You want to be able to confront him about his policy decisions, but you want to do it with facts from the medical records. How do you do that logically connected since he wasn't the one who did the interviews?
Because we know what was told to the families because we had scripts. And
Then ask him if he sponsored the scripts.
He testified during direct examination that he went, met with the prosecutors, they made the decisions as to what and would not be told to the family members, and because they didn't want to interfere with the investigation. We have in evidence the scripts, which are two different scenarios, one involving a detective reaching out to them first, and one involving Mount Carmel reaching out to them first. He was a key decision maker, that's been established at Project Lighthouse, which includes these scripts, as it related to all of these decisions. So he wants to characterize this disclosure to the families as being transparent. Now that's having your cake and eating it too. If I'm not able to cross-examine him specifically as to what he directed them to disclose or not. Now,
But that wasn't what you were doing. You were sitting there testifying about what was in the medical records. You weren't disclosing his policy. You were confronting him with medical information about recitation and other things. And quite frankly, he's not the person to do that with.
Judge, if I have a good faith basis to ask him about a fact that he did not direct them to disclose, that I think that's a narrow question, a narrow avenue that I believe I should be permitted to go into. Now, I agree with the court in terms of not being able to say that he participated in it and he didn't tell the family members this. I agree with that. But as to whether he directed anyone to do this because he's labeling it as transparent, I think that is proper and fodder for cross-examination.
Yeah, but even under your own argument, there's a logical offset there because you want him as to what he said, but you're trying to get in what he didn't say or didn't mention. Which would be either hearsay or speculation.
What he directed them to say.
Okay, but see, you're not doing it that way.
I agree, and I think...
You're doing it by bringing in collateral facts that are in the medical records that he doesn't know what was said to them. He can't speculate as to what was said.
So let me see if I can do it this way, Judge. What I would like to do is I would incorporate the fact that I have a good faith basis for and ask him if he directed anyone to tell the family members that fact.
We would object.
Still a problem.
Thank you.
You can talk to him about the policies. That's what he was testified to. But to go into the medical records line by line, how is that a good faith basis? You're asking him to speculate what's on the medical records unless he's got actual knowledge.
He does have actual knowledge. He just testified on direct examination. He put this Excel spreadsheet together, and then he did all of this work in reviewing the medical records. He's aware of these facts.
I think the court's made its ruling. May I use the restroom? Thank you.
Yes. Okay. If you want to proffer, I'll step out.
So
Can Janet cover the proffer?
I'm just...
David?
Jan can cover the proper. You want the proper.
I was actually moving towards the restroom. I'll cover it.
I'll be right back.
It's all right, go ahead.
I'm step off.
I'm, Judge, just so we're clear, you're denying my ability to be able to go into...
I'm denying your ability to use the question format you're in. Now, if you can come up with some other theory that's not speculative or hearsay,
I have nothing to proffer, so you can go.
Thank you.
There's shooting, Commissioner's garage. Double shooting, Commissioner's garage. We have the suspect in custody. That's that. The problem, they're all orders. One of each for every 12 hours. Okay, now,
Friday night, I was at dinner at if you do, but go ahead. You can be seated. Paul's our tech guy here, and he's done his little miracles here, and we've got it back up on the big screen. How long it's going to last, I don't know. Okay? Doctor, you're still under oath? You may proceed.
Dr. Roth, the reason that you met with the prosecutor multiple times and also with the media multiple times was because, in fact, you were aware that it was your position, that your position would be strengthened by indictments, correct?
No, it's not my understanding.
You're aware that that's what the thought process was behind Project Lighthouse, correct?
No.
Sir, I'm now showing you what's been Defense Exhibit MCD 11. That is a draft communications from plan and playbook from Project Lighthouse. Do you see that, sir?
I can't.
Okay. And for the record, that's MCD
Is it on your screen right there?
11?
Okay.
Okay. So right here, it gives you background and objectives. That's the first part of it, correct?
That's correct.
And then the strategy, right?
Correct.
Okay, on page 2 of the strategy, it says, while our position would be strengthened by an indictment, or S, our argument must be able to stand on its own regardless of what the county prosecutor does. You see that there, sir?
I do.
But yet it's your testimony that that was not your goal, correct?
Correct.
In addition, one of the strategies that you had was our messaging must appeal to the heart as well as the mind. The messaging from the doctor and nurses and pharmacists, who we have called the villains, will likely be heavy on emotion. Quote, we were just trying to alleviate acute suffering in the patient's last few minutes of life. Our emotional argument must be stronger. That was the strategy behind Project Lighthouse, was it not, sir?
That's what that document says at that point in time, yes.
But of course, that's not what your testimony is, right?
My testimony is that
You were just trying to be transparent.
Objection, Your Honor.
Okay, you can finish the answer. Is that your testimony?
yes.
That you were just trying to be transparent, right?
Yes.
Is that a yes? Now, you testified under direct examination that the only reason you hired a criminal defense lawyer to make this connection with the county prosecutor was because you guys were unfamiliar with how the criminal justice system works, right?
That was the main reason, that's right.
Okay. And you testified under direct examination when asked, I want to make sure I get the right word that you used. This one. Dr. Roth, you know they say young eyes are better than the old ones, right?
Yes, sir.
All right. Back to my last set of questions. I'm again showing you the MCD 11, which is the plan and playbook for Project Lighthouse. On the last page, it says key audiences and spokespersons. And then it gives a list of people internally who you want to be the audience, right?
That we would need to communicate with, yes.
And then you have the external people, right?
Correct.
And that includes elected officials,
Correct.
like the prosecutor, the county prosecutor is an elected official,
He is. I don't know if that was specifically the reference for that.
okay? And then you have your media, local, national, trades, you see that?
Correct.
And then it lists here who the key spokespeople will be, right?
Correct.
And on there it gives Mount Carmel, starts with Ed,
Yes.
and under Trinity Health, who's the first person listed?
My name. I am.
So when you testified a minute ago that it wasn't your plan, it's just what the document says, that's not what the document says, correct?
Well, the document that was at a point in time on December 19th, when I met with, say, the dispatch, that was 4 weeks later.
So you had a change in strategy that indictments would not strengthen your position. Is that what your testimony is, sir?
To my knowledge, that is correct. That was not our primary purpose. Our primary purpose was to communicate what had happened.
But yet, it was you who met with the county prosecutors once, twice, three, four, 5 times. Correct?
Correct.
And in these 5 meetings, the first meeting you went to on the 17th, it was just you, the general counsel for Mount Carmel, and the vice president of planning and strategy, right?
That from a Trinity Health and Mount Carmel perspective, at the December meeting?
Yes.
Yes, I believe that's correct.
So basically, it's you, a lawyer from Mount Carmel, and the press person from Mount Carmel, right?
And I believe Greg Peterson was there as well.
The criminal defense lawyer.
Yes.
So there's nobody there from Mount Carmel who was actually at the bedside or supervising those at the bedside to give facts to the prosecutors, right?
That would have happened through other channels.
My question to you is, there was nobody there who was at the bedside or who supervised those at the bedside that could give them facts, right?
Not at those meetings.
So then, the second meeting, it's you, again, criminal defense lawyer, you and 2 lawyers, right?
Correct.
Not even anybody from Mount Carmel, right? Except the lawyer.
Correct.
Then the third time, it's just you and the lawyer, right?
The third, can you give me the date for the third time, please?
February 5th,
Yeah, same group of people.
okay? And you said that you don't recall February 7th, so that I won't ask you about. But the next time, on March 11th, it's just you and the prosecutors, correct?
No, I believe the same group of people were at each of these meetings, or at least those meetings.
So you and the lawyers.
Correct.
Again, nobody from the bedside or who supervised those at bedside that can give them facts, right?
Not within these meetings, that's correct.
And that's because your position would be strengthened with an indictment, right?
That is not the purpose for those meetings, no, sir.
This was all before Dr. Husel got indicted, that you met with the prosecutor, right?
Those meetings were before Dr. Husel was indicted, that's correct.
Now, while we're talking about lawyers, it was your testimony in direct that you hired a lawyer, Greg Slimmer, did I get that name right?
Mount Carmel did, that's correct.
Okay. For all the nurses and pharmacists, right?
Yes.
Okay. Despite the fact that that's one lawyer representing a potential conflict of interest of having represented all of these lawyers, all of these
Strike
nurses and
that.
pharmacists?
Ladies and gentlemen, disregard the question. Let's ask a proper question.
Sir, you're aware that one lawyer can't represent all of these nurses and pharmacists, right?
I'm not aware of how many a lawyer can represent or not represent.
And you're aware, or are you aware, sir, that this lawyer never attended a single interview by the detectives with his or her, his prospective client, or his actual client?
I am not aware of that.
So one lawyer representing all of these nurses and pharmacists didn't sit in for one single meeting with the detectives. Are you aware of that at all?
I said, no, I'm not aware.
And you stated that one of the reasons under direct, you were asked by the prosecutor as to whether it was a concern whether a hospital or its administrators would be charged with a crime. Do you recall that line of questioning?
Generally speaking, yeah.
Okay. And you stated that it wasn't a prominent concern, correct?
Correct.
But it was a concern, was it not?
Yes.
Okay. And in fact, it was a concern because you're aware that there have been numerous hospitals and administrators who have been charged with their failure to control opioids. Is that a fact, sir?
No, and I'm not aware of a parallel case.
No, I'm not talking about a parallel case. What I'm asking you, sir, is you're aware that there was a major crackdown on hospitals and administrators as to their controlled substances.
Nationally speaking, yeah, that's right.
And that's something in your position that you have to be concerned about, right?
Yes.
And you're so concerned, sir, that you, in fact, have not one, but two lawyers who escorted you here today. Right?
Okay.
Your Honor,
Objection sustained.
Sir, you've retained your own criminal defense counsel, have you not?
Yes, I have.
objection, Your Honor.
How's it relevant? He has the right to counsel. Everybody has the right to counsel in the United
Yes, because
States.
it's an obvious concern of potential criminal charges.
Okay.
Lay outside of the jurisdiction.
No, we're done. Sustained. Next question, disregard the last question in the conversation.
Sir, you stated under direct examination that you recall the line of questionings about Katie Barga not being a clinician. Do you remember that?
I remember asking whether she was or wasn't, being asked whether she wasn't a clinician. That's correct.
Katie Barga didn't conduct this root cause analysis investigation by herself, right?
Correct.
There, in fact, was a team of medical professionals that were involved in this, correct?
Correct.
Including yourself.
No, I was not directly involved in that.
You didn't supervise it or were a part of it in any way, shape, or form?
I reviewed it after it was completed.
And you were aware that palliative care specialists were also involved?
Correct.
Now, sir, you also testified about your self-reporting to all the numerous agencies. You remember that?
I do.
And your testimony is, again, that you were trying to be transparent, correct?
Correct.
And part of that transparency was self-reporting to CMS, right?
I believe so, yes.
Sir, you know that you were contractually obligated to report to CMS under the ACO. Isn't that correct?
Correct.
So it wasn't because you were trying to be transparent and a good guy. You had to report to CMS. Otherwise, you would have been in violation of that contract with CMS, correct? Oh, excuse me, with ACO.
Yeah, because specifically this is about the ACO, not about, on direct, it was around Mount Carmel's participation with CMS. Those are two separate issues.
And you had to report to them.
With regard to the ACO, yes, sir.
And what is the ACO for the ladies and gentlemen of the jury? What does that mean?
So the ACO is a relationship that Trinity Health enters into with Medicare to be accountable for the quality, cost, and experience of patients who have Medicare across Trinity Health.
Judge, if I could have a moment, I want to see if I have anything further. I have no further questions.
Mr. Zion?
Give me a minute.
I see MCD, please. MCD 11.
Sure.
Yeah, thanks. Do you recall Mr. Jose, a moment ago, referring to what they've labeled as MCD 11, and him quoting, I believe it was this first part, our messaging must appeal to the heart as well as to the mind. Was that what he was referring to when he was quoting from this? Or was it on a different page?
I believe it was that section.
This is the section. The messaging from the doctor, nurses, and pharmacists, as he's quoting it, he said, who we will call the villains. Is that in there? Is that actually in there?
It is not.
Oh, okay. Let's talk about this villains document. Did that plan get implemented?
It did not.
When did that plan change?
To the best of my recollection, it was around between the week prior to and the week after Christmas of 2018 and early into 2019.
And is that the time you were taking over this investigation and this crisis?
I was more directly involved, that's correct.
I'm sorry. I didn't hear your answer.
Someone coughed in the back.
Yeah, I was more directly involved, that's correct.
And was it your specific intention to not go that way and go a different way?
That is correct.
And what way did you believe was the appropriate way to handle this situation?
To inform the families what had occurred and what we were doing to investigate it and to share that publicly at the right time.
And as you testified, other public agencies?
Other agencies, yes, that's correct.
And did that include the county prosecutor's office?
It did.
And did you dictate to the county prosecutor how they were going to conduct their investigation?
I'll permit it's transitional.
I
Any
did.
other question?
I did, Your Honor.
Okay.
I did not.
Did you dictate to the homicide detectives how they would conduct their investigations?
I did not.
Did you defer to the county prosecutor's office?
I did. On the matters of their investigation.
Did you defer to the detectives, the homicide detectives?
I did on the matters of their investigation.
Did Bill Gillette, did you meet Bill Gillette? Do you remember who that was?
I do.
Is he a doctor to your knowledge?
He is not.
Did he have a strong grasp of the medical issues that were involved? To your
To
understanding?
my understanding, he did not.
Are you a doctor?
I am.
Did you have a grasp of the medical issues that were involved?
I did.
Objection.
I'll permit it. Let's move.
In these meetings with the prosecutors and the police, did you
explain to them the medical issues involved?
I did. I spoke to them to the facts.
Are you an attorney, sir?
I am not.
Do you have any specialized experience with criminal law?
I do not.
Did you hire those around you that might?
I did.
Why?
Because the complexity of the situation meant that we would be dealing with those issues, and we wanted
This
to.
is beyond the scope.
I disagree. I'll permit it.
This was objected to by the prosecutor and sustained, and now he's asking about it.
No, one part of it was you're correct, but I'll permit it.
Would you mind restating the question? I apologize.
Why?
Because there are aspects of the situation that were going to involve those parties, and we wanted to make sure we had the full understanding of that.
All right.
I would object to that.
All right, well, then we can approach.
Okay, let's approach then. Thought I'd get through a session. How was your soccer game this last weekend, Ms. Schaefer?
We got beat up.
Oh, well, I bet they're just dying to find out how badly they were beat up.
Look at that, see if you recognize that document.
I do.
What is that document?
That's an article in the Columbus Dispatch.
For the record, 27A is an article in the Dispatch from, what?
We have a 27A, maybe B.
We'll make this 27B, Your Honor, my apologies. 27B, an article from February 22nd of 2019. Does that sound right?
Sounds right.
It references, quotes repeatedly, a Dr. Dan Roth, Executive Vice President and Chief Clinical Officer of Michigan-based Trinity Health. Who is that?
That is me.
And are you quoted by name and occupation in there?
I am.
So when you recall giving interviews with the media, did you do this anonymously, or I think the phrase was off the record, or were you identifying yourself and being quoted in those media releases?
I was identifying myself and being quoted in those.
And was this part of your effort and Trinity's effort to be transparent in this process?
It was.
Did you frame Dr. Husel for murder?
I did not.
Did you tell the county prosecutor to frame Dr. Husel for murder?
Objection, Judge.
This is right answering their question, Judge.
I'll permit it.
I did not.
Did you tell the homicide detectives that they had to frame Dr. Husel for murder?
Judge,
I did not.
My questions had nothing to do with framing anybody.
Okay, you may not use the framework.
And it's leading.
Overruled.
And it's leading.
It is leading. Rephrase.
Who, if anyone, did you tell the police to frame for murder out of the dosing habits of Dr. Husel in the nighttime ICU during palliative extubation?
Objection, Judge.
That was open as can be. Who, if anyone?
I know, it's overruled.
I did not tell anybody to do that.
Thank you. Nothing further.
Okay, you may step down, thank you. Call your next witness.
Call Dr. Ralston to the stand.
We can at least get started with him, we got some time. You guys holding up okay? Did you flood him with sugar this morning again?
No.
Not yet? Okay. Yourself comfortable. You can lower your mask if you're more comfortable, it's up to you. Okay? Okay, I need you to state your name for the record. You got that aerial mic there in front of you?
Okay.
State your name for the record and spell your name so that my court reporter can get used to your voice.
Sure. David Ralston, D-A-V-I-D, Ralston, R-A-L-S-T-O-N.
Can you all hear him? Yes. Madam Court Reporter? Okay, Mr. Zion.
Thank you. Can you tell the ladies and gentlemen of the jury what it is you do for a living?
I am an ICU and pulmonary physician and sleep physician at Mount Carmel.
And how long have you been so employed?
Since 1997 with Mount Carmel.
What type of education, starting with college, did you need to do to become what you do today?
I went to college at Miami University. I then went to Ohio State Medical School. I then went into an internal medicine pediatric residency program for 4 years. And then I went to a fellowship in pulmonary critical care for 3 more years.
So that we could give you some so that you could give them some reference how long you've been doing that. What year did you graduate medical school?
1990, I'm sorry, 1990.
All right, and then you were an MD at that point?
Yes, sir.
Licensed to practice in the state of Ohio?
With limitations, being a resident, yes.
Okay, so 32 years ago?
Yes, I guess so, yes, sir.
32 years you've been a doctor or graduated medical school? So what was your first residency in?
In 1990 through 94, I went into internal medicine pediatric residency, where I was eligible to be board certified in internal medicine and pediatrics.
And did you become board certified in either one of those areas?
I became board certified in internal medicine. I was wanting to be a family doctor, but then I fell in love with pulmonary and critical care medicine, so I did not become board certified in pediatrics.
Did you take any additional training or classes in critical care or pulmonary medicine?
After the residency, I had to do a 3-year fellowship in pulmonary and critical care medicine from 1994 through 1997.
Tell us what pulmonary care medicine, pulmonary, what does that word mean? What are we referring to when we say pulmonary?
Sure, it involves the treatment for patients with lung issues in general.
Okay. And critical care, pulmonary critical care. Describe to them what that involves, what a pulmonary critical care doctor does, and what you were trained to do.
Sure. A critical care physician is responsible for taking care of very sick patients in the ICU. Usually these patients are on the ventilator, and our role is to work with the patients to support, put them on life support, and then eventually try to get them off life support once their disease process is hopefully improved.
And you got that board certification in 1994?
I got that board certification, I think, in 1997.
You started in 94, I think you said.
Yeah, 94, yes.
Okay, so in 1997, what do you do once you're board certified in pulmonary critical care medicine?
I joined Mount Carmel at that point on their private practice group at that point.
Can you describe what that means and what you're doing on a daily basis then in 1997?
Sure. Basically, we would see, it would vary on a weekly basis. We'd have weekly rotations. I would work in the office for 1 week, seeing outpatients, patients with lung problems in the office. I would then rotate into the ICU for usually a week at a time. And then I would also see patients in the hospital on the floors with lung problems in general as well, too.
So you're taking care of people in like an office setting, like I have lung problems, I go to you, call up, make an appointment, and you look at me and you're examining at the office.
Yes, sir.
And then you're also seeing people in the ICU, those would be generally people on ventilators?
Yes, in general, the very sick patients in general, yes, sir.
But then you're also walking to the other floors if, say, I'm not sick enough to be in the ICU, but I'm having breathing problems. They might call Dr. Ralston in to see what's up with my lungs.
Yes, sir, as a consultant.
Okay. So how long did you do that? That started in 97, so that's 25 years ago?
Yes, sir.
How long are you doing that?
I'm still doing that today, yes, sir.
Okay, so you've done this for 25 years.
Yes, sir.
Now, just to be clear, are you an employee of the hospital itself?
I was not an employee initially. For several years, I was in private practice, but over the past, I think, it's about 5 years or so that, yes, I became part of the Mount Carmel Medical Group, which is the physician component of hospital physicians, basically.
Okay. And the company you work for, is it fully owned by Mount Carmel then?
I'm not sure.
Fair enough. Fair enough. But you work for Mount Carmel, but you're not like exactly an employee of Mount Carmel. There's a company there.
Yes, that's correct.
Okay. And does your company manage the ICU?
We're consultants in the ICU, yes.
All right. And back in the relevant time frames, 2013 to 2018, what, if any, responsibilities did you have regarding the management of the intensive care unit at Mount Carmel West?
I was the medical ICU director at that point.
So tell the folks what the medical ICU director does and what your responsibilities were on a day-to-day basis.
Sure. Not necessarily a day-to-day basis, but it's more administrative in general. They would ask my opinion about a new ventilator of some sort, a new defibrillator to shock patients' hearts, to report to all the governing bodies, for example, issues with infections, secondary infections, things like that.
Okay. Did you have any other administrative duties as far as scheduling, things like that?
No. No, sir.
Okay. Tell us prior to 2013, what, if any, doctors were on the night shift at the ICU?
Sure. At the time, Mount Carmel is a teaching program, so we had young physicians in their internal medicine residency at that point. They were in training, and so they would be responsible for the care of the patients at night with myself and my partners readily available by phone if any issues, or even to come in if necessary.
But were you actually physically at the hospital, you or your partners?
No, sir.
And residents, those are the folks that have graduated medical school and they're still training?
Yes, sir.
All right, so they're still kind of student doctors at this point?
Yes, sir.
Okay. So at some point, did that change regarding the coverage of the nighttime ICU?
Yes, the residency program at that point, because of some of the work hour shift in thinking, working hours, not wanting to work them too long, they decided not to provide ICU coverage at night with the residents at that point.
What, if any, change occurred to your knowledge?
At that point, you needed to have physicians at bedside at night, so therefore, 2 physicians were hired to provide the nighttime ICU coverage.
Do you recall the names of those 2 physicians?
Sure, Dr. Husel and Dr. Hagris.
Is Dr. Hagris still part of this group working nights?
Yes, sir.
Were you part of that hiring process?
I talked to the physicians, but it was not ultimately my final say one way or the other.
And this was in 2013?
Yes, sir, by best recollection, yes, sir.
All right. Can you tell the ladies and gentlemen of the jury what, if any, interactions you had with William Husel, one of the 2 that were hired, and/or Dr. Hagris, just in general, and then any specific interactions you recall having when they began?
Your Honor, it's a compound question. If we could
Rephrase.
Did you have, what, if any, interactions did you have with Dr. Husel when he was hired?
When he was hired or after he was hired, I
Well,
apologize.
at that time, in 2013. I mean, did you walk through, just tell them what you did.
When he was hired, I sat down with him. He told me his background. I told him what to expect with the job, basically. I'm sure I gave him a little tour of the ICU at that point. And that's kind of my interactions with him.
What about Dr. Hagris?
objection is to relevance.
I'll permit it.
It was probably the exact same thing that I did with Dr. Husel.
And they were hired about the same time?
By my recollection, yes, sir.
All right. And were they hired for a specific shift?
Yes, they were hired to work from 7 p.m. to 7 a.m.
All right. Did they split the week then?
Yes, they would get together and make their own schedules and things like that.
All right. So what were your hours and what were your partner's hours?
We really don't have shift work. We basically would show up around 8:30 in the morning, and then we would basically stay until all the work was done. Sometimes that would mean we had to stay because of some of the governing bodies' regulations, but sometimes it'd be an 8-hour day, some days it'd be a 12-hour day. You can't predict sometimes with the ICU.
Okay. And is, just so for the jury's reference, is Dr. Gianlupi one of your partners working day with you as well?
Yes, among others, yes.
Okay. So what, if any, interactions on a day-to-day basis between 2013 and 2018 did you have with either Dr. Husel or Dr. Hagris?
Objection, Your Honor, is to compound.
Two-part question is,
Yeah, well, that's a very objection.
what interactions between 2013 and 2018 did you have with Dr. Hagris?
If I was there late, taking care of a sick patient, I would say, hey, there's this sick patient, keep your eye on tonight. Or if there was a patient expected from an outside hospital, say, hey, there's a patient coming in. It was professional sort of checkouts as much as possible. The residents would do the formal checkouts, but if I was there late, which I was fairly often, I would be focused on specific patients in general.
What about with Dr. Husel?
Very similar.
Did you have any interactions with Dr. Hagris outside of your professional relationship?
No, sir.
Did you have any interactions with Dr. Husel outside of your professional relationship?
No, sir.
Could you characterize how often you would have these interactions?
It would depend
Interactions.
with Dr. Husel or Dr. Hagris.
Let's start with Dr. Hagris.
Okay. It would depend if, obviously we're on a rotation, so in the weeks in the ICU, I would have those interactions. On the weeks I'm not in ICU, I would have 0 interactions.
What about Dr. Husel?
Very similar.
All right. Were there ever any formal or informal team meetings that would be arranged with the the 2 nighttime ICU doctors?
Yes, Dr. Swanner would have set meetings with them, and if I could attend, I would attend the meetings, which I think was a good thing.
What was the nature of these meetings? What in general would we discuss?
Basically, just to see how things are going at night. You don't want the night people to feel isolated or that they're not appreciated. Having a night ICU doc is precious. You want to make sure that they're happy. Otherwise, I would be the one working nights in general. So you want to make sure that they're happy. They may bring up issues that you didn't even think about that occurs at nights and things like that.
Were any of these issues ever brought up to you by Dr. Husel?
No, sir.
What was Dr. Husel's training, to your understanding?
He was at the Cleveland Clinic and had done anesthesia as his critical care pathway.
Explain what that means, his pathway versus what?
Well, my pathway is internal medicine, so I did an internal medicine residency first, and then on top of that, I did the critical care component, a pulmonary critical care component on top of the internal medicine component. With there's several pathways you can become critical care certified, and that's the other way is through anesthesia because they also deal with the ventilators and things like that. So he did. I'm guessing I don't have his CV in front of me, but he did, or his resume. He went through an anesthesia program and then did an additional year of training in critical care.
All right, so your pathway was internal medicine versus your understanding of Dr. Husel's pathway was anesthesia and then critical care.
Yes, sir.
And are there other pathways to become a critical care doctor?
I think there's also a surgical pathway. People who are surgeons can also do additional training and do surgical critical care. And even the neurosurgeons, I think, have a way to do neurocritical care, which is more specialized than just general critical care.
So there are several paths to do what you do.
Yes, sir.
All right. And you've done this since 1997. Do you know what Dr. Husel's prior experience in critical care was prior to him being hired in 2013?
No, sir. I thought he was just probably fresh out of his training. I thought, if I remember correctly.
All right. And are there any other doctors with Dr. Husel on a regular basis working his night shift with him?
Towards the end, I think we were incorporating some critical care nurse practitioners in general, but that would be about it.
Yes, but any other doctors, any other critical care doctors?
No, sir.
So that if there were questions on that shift, there were no other critical care doctors working with him?
That is correct, yes, sir.
And Hagris would be working the other part of the week?
Yeah, it would be rotating every other week. So one week it'd be Dr. Husel, the next week it'd be Dr. Hagris, unless they were on vacation or something.
If Dr. Hagris had any questions for you or for your team during the daytime, you having done this since 1997, could they have reached out to you at any point?
Yes, sir.
Could Dr. Husel, if he had any questions, being a new doctor to your understanding, reached out to you or to your team at any point with any questions or concerns? Could that have happened?
Yes, sir.
And to your memory, in the 5 years he was there, did that ever happen?
I don't recall that ever happened, no, sir.
So let's talk about palliative extubation. What does that term mean to you as a medical critical care doctor?
That means at that point you are removing life support and without plans of reinitiating that life support, and you still care about the patient, but your focus is more on comfort at that point.
All right. So that's what the palliative part means?
Yes, in general, yes. I use a different term, but
What term do you use?
I use compassionate extubation is the term that I use.
So instead of palliative, you use the term compassion.
I think it's easier for the families to use and interact with families. Palliative or terminal extubation is just harsh, I think, in general.
Sure. But terminal extubation, terminal weaning, those are the same things.
A terminal extubation and terminal weaning is a little different. Terminal extubation is where you take the tube out of the mouth, while terminal weaning is where you just turn down the oxygen on the ventilator.
All right, so tell them about specifically what's involved. So palliative means comfort care. Use the word compassion meaning comfort care. What's the extubation part mean? Explain to them what that physically involves, why that word is being used.
Could you repeat the question? I guess
What does extubation mean?
Oh, I'm sorry. It means to physically take the breathing tube out of someone's trachea or windpipe, the big pipe in the lungs, and to take it out at that point.
Okay. And are there other times when you would extubate somebody besides in a palliative or compassionate setting?
Yes, sir. Hopefully, when patients are better from pneumonia or when their lungs are damaged from smoking, and you can get them off the ventilator that way.
For people that you hope are going to live after you pull the tube out.
Yes, sir. Absolutely.
So let's talk about a regular extubation. Someone's going to get better in your estimate and everyone's estimate. And it's decided medically to pull that tube out and get them off the ventilator, the machine breathing. What, if anything, is involved pain medication-wise in that process? In that process of we're going to continue on with their care.
You don't necessarily give pain medication at that point. You actually try to decrease the pain medications to a reasonable level so that they're awake enough to cooperate with you once the tube is out. That way the patient can cough and bring up secretions and help you with the extubation process.
Okay. What about benzodiazepines in a regular extubation, not compassionate, not palliative? What about any benzodiazepines? Do you give them any benzodiazepines when it's expected that their care will continue and life-saving care will continue?
Your Honor, I think it's irrelevant as to what's done with those that are going to continue life-saving measures.
I'll permit it.
No, you would try to those are like Valium-like medicines that help relax you, so you would try to keep those at the lowest dose or discontinue those as well too.
So based on your training and experience, is the process of pulling that tube out, tell them where that tube is first. How's it get down there? Where is it? What's it doing down there?
It is placed through the mouth, between the vocal cords, and then put into the big pipe in the going to both lungs called the trachea, the big breathing tube right here.
Okay, so for the record, you're pointing like
To the middle of my chest, yes.
Yeah. And is that process, intubating someone, is that painful based on your training and experience?
It is uncomfortable. You do give medications to sedate the patient while you do that, because it's very normal to, I always make an analogy to families. It's like getting your throat swab for strep. You cough, you gag. It is uncomfortable. Put the tube in. Yes, sir.
All right. What about pulling that tube out? What's your experience and your training tell you about the level of pain and or anxiety that involves?
Most patients are glad to have the tube out because they're very awake and alert. You will gag a little bit, but the ongoing stimulus of the coughing and gagging has been removed, and so it's very slightly uncomfortable, but it's not painful in my experience.
Mr. Zion, can I see counsel sidebar?
Yes, sir.
Talk. So did you find out anything interesting about the jurors weekend?
We were talking about coaching.
Ah. It's one of her favorite hobbies. You ready there? Mr. Zion?
So let's talk about palate extubations. That's when, as you explained, you're not expected, we're shifting to comfort care at this point. No further medical life-saving measures are going to be used, right?
Yes, sir.
In your experience, what is that process? Not talking about in general, I'm talking about subjectively, your experience. What's the first thing you do?
It's a pretty lengthy process. You want me to go through?
Yes, I do.
Okay.
Well, first things first, Doc. Have you ever done one?
Oh, yes, sir.
Okay. Now you can take off with it.
Thank you. How many do you think you've done?
Too many, I guess, with COVID, to be honest with you. Over my career, over 20 years, maybe 1,000 or so, and that I don't keep track. I don't know.
So you say it's a lengthy process. Start us at the beginning of this lengthy process.
Basically,
We'll get back here. I want you to speak up.
sure. Basically, you want to make sure you have a very good relationship with the family. You want to sit down and talk to them, and when they hit the ICU, you really want to find out who can legally make these sort of decisions, who's the decision maker is what I always call, who's the decision maker. You want to establish a relationship with the family. They want to be able to trust you, and you want to relay trust and confidence to them as well too. And then at that point, you've been updating them every day. I make family rounds every day. You update the family. You talk to them. At that point, ultimately, sometimes the body says they're not going to make it, essentially. And you sit down with the family and you try to figure out what that loved one would want under these circumstances. The first transition is you try to eventually but discuss with family. Code status is the first thing.
Explain code status to the folks here. No questions.
Sure. There's 3 codes in the state of Ohio, 3 code levels, for lack of a better term. One, obviously, is a full code. As I always tell families, if you keel over, I'm trained to come running in, try to restart your heart with the best technology available, best skills available. Not guaranteed, but we try our best. The second is a DNR CC, which is DNR Comfort Care Arrest, which basically means we do everything up until the point where the heart stops. At that point, the heart stops. We don't come running in, shock the heart, beat on the chest, put tubes in the airways, things like that. Now, obviously, the third one is DNR Comfort Care, where at that point, again, the care doesn't stop. You still care about the patient, but your focus shifts on comfort as a top priority. So the first thing you want to do is, at least as a family, is DNR CC arrest is usually the first step, because really this patient came in, usually it's a tragic event. The family's in shock, essentially. And so you want to give the family time to digest everything, talk about end-of-life issues as honestly and realistic as possible. And then after time, you sit down with the family and you say, the family will say, under circumstances, we don't want further aggressive interventions. And then they say, well, that sometimes means taking the tube out. And I try to go through that whole process of what that entails. And then I always like to have lots of ears in the room sometimes to listen. I like to get the bedside nurse in the room when I talk to the families and things. We have chaplain support that's always nice to have. And it is a process over time, but when the family reaches that, when I and the family the family is the patient advocate, I'm the patient advocate as well too. And at that point, if we decide somewhat together that it's time, then we start the process, we kind of pick a date and a time which is convenient for the family. we try to avoid holidays and birthdays and things like that. And then at that point, we would give medications to ease suffering and take the tube out with the family at bedside. I always like to be present, and then I like to always just stop back by 10 minutes later, 15 minutes later, to at least say, hey, how's things going, and talk to the family as well, too.
So you said it's a planned event.
Typically it is, yes, sir.
In your 1,000 or so, would you ever characterize any of them as emergencies?
No, sir.
Let's talk about the medicines you give. You said on a regular extubation, you try to decrease the benzos and the pain medication. On a palliative extubation, or your words, compassionate extubation, you said you give medicines. Tell them why you're giving them medicines at this point, and at what point are you doing it? Are you doing it before the tube comes out, after, etc.?
Sure. Based on the disease state of the patient, sometimes I give medicine ahead of time. I use morphine in my practice. That's what I use, morphine. I use a drug called Versed or midazolam it's a Valium sort of medicine. It's a relaxation medicine. The nice thing about it also has amnesia properties as well too. So it takes away memory of this. And this is after I've prepped the family pretty hard. Here's what to expect. Here's what could happen. Things like that.
What specifically are you preparing them for? What are symptoms, etc.? Tell us.
Sure. I basically talk to the family that the medicines that I give act on the top part of the brain. That's the part of the brain that perceives pain and suffering. But the human body is an amazing thing. It really is an amazing thing. The body will fight to live, even though the chemicals I'm giving affects the top part of the brain, so the patient's not perceiving pain, but the patient certainly may breathe fast, may have problems swallowing the spit from the back of the throat. Secretions is sort of the term for that. I always tell a family, you can be in the room when we take the breathing tube out. You can be outside the room and come right in. You can stay out in the waiting area, or you can be in the next county. I always say it's a personal threshold. We all have personal thresholds, and it's not a test of love to be in the room when this occurs.
Tell us about are there terms for that? Held your hand to your throat and said the rapid breathing. Is there a term for that?
Yeah, it's called agonal breathing, which may be either rapid, fast, shallow breathing, or it may be just intermittent gasp, intermittently, not a normal breathing pattern.
With the medications you give them ahead of time, or at whatever time you think is appropriate, that affect the top part of their brain, the benzos and the morphine, that guppy, agonal breathing, is it also sometimes called guppy breathing? Am I using the right term there?
Sure, the rapid, shallow breathing, yes, sir.
Okay. Is that in and of itself inherently painful or anxiety-inducing for the patient?
For the patient, no.
And is that why you prepare the family for that possible symptom of the dying process?
Right. I tell the family that we are going to do the best to relieve any suffering as much as possible. But again, the human body's, once you take the breathing tube out, the dying process is the dying process.
What about secretions? Is there any medicine you can get part of this planning process to help with the secretions? Is that also sometimes referred to as the death rattle? Yes,
it's the noise in the back of the throat. Typically, we can give drying of secretions. Atropine is a commonly drug that's used. There's other medications. And you basically try to give that ahead of time a little bit as well, too. Sometimes it's very successful. Sometimes it's not as successful as I would want.
Now, when someone is intubated on the ventilator and before the DNR, CCA, or CC decision is made, do you ever give patients paralytics?
When a patient's on the ventilator? Yes, sir.
And what would be the purpose, what is the purpose of paralytics? And then first explain what are paralytics and what would be the purpose of giving them to them?
when you're paralyzed, I always make the analogy, it's like when you're going for surgery. You can't move. You don't want the surgeon cutting on something that's moving or anything, so you are actually not able to move. There's chemicals that prevent you from moving. When you're paralyzed with a ventilator, that basically means we are taking total control of your breathing at that point. That improves at times. The lungs' job is to do two things. One is to get in oxygen. The other is to get rid of the waste product, which is the carbon dioxide. And so therefore, the lungs, the paralytic, when we take over total control of the breathing, the goal is to improve oxygenation and ventilation with the ventilator.
What, if anything, as part of this sometimes long process of preparation for palliative extubation, compassionate extubation, do you do in regards to paralytics that a patient might be on?
It's extremely important to make sure that the paralytics have been cleared from the bloodstream.
Why is that extremely important?
Okay, hold on, doctor. That's in your practice? That's in your practice?
Yes, sir.
Okay.
I'm sorry.
Yes, and all of this, if I say anything, ask you to opine about something that's not, I'm talking about your practice, your experience.
Sure, and I guess I should phrase, in my practice, I guess, you have to stop it ahead of time because you don't want to take the tube out and then the patient not making any effort of breathing because that's not ethically the right thing to do.
Why not?
Objection, Your Honor, is what's ethically appropriate.
Yeah, I agree.
Okay,
Sustained.
ethics aside, in your experience, in your practice, what would happen to a person on paralytics when you take, if they're still on paralytics when you take them off the breathing machine?
Well, it deprives me of two things. One is the ability to assess how much pain and discomfort they are in because they can't respond to any stimuli. And it basically would not allow them to breathe even once you take the tube out.
I thought the purpose was so they could die. What difference does that make?
Your
Okay,
Honor,
sustained.
objection. And move to strike.
And strike. Disregard the question.
How long does it take paralytics to wear off?
It depends on the disease process, how much liver disease, how much renal disease is present, the type of paralytics that you use, it varies, and you have to check for it before you take the breathing tube out, that it's cleared.
Okay, how do you check for it?
You do what's called a train of four. Fancy term, train, like a choo-choo train, but you put things to stimulate the muscles, and it puts a little electrical shock, not painful or anything. I do that to the residents to show them, but it basically makes you, if you give a little electrical shock, your hand will twitch, and you want to see all four twitches. If you give the shock and it doesn't twitch, that means that they're still paralyzed at that point.
And how do the paralytics clear the system?
Usually by either coming out in your urine, you're renally excreted, or cleared by the function of the liver.
So they just come out of that, it's just a matter of time?
Yes, sir.
And as part of this planned procedure, you have that time?
Yes, sir. And you prep the family ahead of time to tell them you would have to make sure the paralytic is cleared.
All right. Let's talk about the medicines you use as part of the palliative or compassionate extubation in your experience. What would you generally start with and the doses you would use?
Sure. Obviously, every patient is unique and different. Sometimes I would give the pain medications before the extubation, sometimes afterwards, but typically I use 2, maybe 4 milligrams of morphine and 2 of Versed.
All right. And do you use those at the same time?
Yes, sir.
And clinically in your practice, do you do that before extubation, during extubation, or after extubation?
Again, it's very patient-specific. Some patients, I feel comfortable with their disease process. I do not have to give it before extubation. If I do, I try to give it 10 minutes or so before to allow it to kick in or be effective. And then afterwards, we would give it based on as-needed basis, called PRN, as-needed basis. And then we can give more smaller doses as necessary in that process.
Is there any danger in giving too big of a dose based on your training and experience and your practice?
Objection, Your Honor.
Okay, it's a great time to go to lunch. Ladies and gentlemen, the guy is here to supposedly fix the system. So let's come back at 1:15. Almost still only 15 minutes to make up for whoever was stuck in the traffic jam this morning. I heard it was horrible. Okay? I'm the one who gets to sit, I guess. I should stand. You guys have a great lunch. Okay, you can be seated. Doc, you're on the stand right now. You can't discuss your testimony with anybody. So if anybody comes to you and they